Ever feel like understanding the law is almost like a superpower we all wish we had?
Definitely. One minute you're curious about, say, shared property.
Right, and the next you're wondering what happens after a minor car accident.
Exactly. It can feel pretty overwhelming.
So, for this deep dive, we're actually tackling a listener request to really sort of get a grip on some key legal areas right here in South Australia.
hmm
We've pulled together a whole stack of resources, things like community titles, court fees, de facto relationships, debt,
Drink driving, drug driving, enduring powers of attorney. Quite a list.
family law, floods and insurance, going to court, debt recovery, car accidents, noisy neighbors retaining walls.
Strata titles, trees, wills, the works.
Yeah. And our mission really is to pull out the vital stuff from these sources to give you, the listener, a clearer picture of the legal landscape that, well, touches everyday life in SA.
Exactly. Think of it as a shortcut, maybe. A way to feel informed about your rights, your responsibilities, without needing that law degree. We're not just skimming. We're aiming to go deep into what you really need to know about these areas, equip you with practical understanding, maybe even a few surprising bits along the way.
Okay, sounds great. Let's kick things off with community titles. We've got the Community Titles Act and the regulations as our guide here.
Right.
So for someone new to this, what's the essential difference? Owning a regular house versus one under a community title.
Okay, the key difference, it really boils down to shared ownership and shared management.
All right.
With a standard title, you generally own your land and the house on it outright, more or less.
Right, your patch.
Yeah. But a community title, that's governed by the Community Titles Act 1996 and the Community Titles Regulations 2011. It involves owning a lot within a bigger scheme. And there's common property shared with other owners.
Shared property, like
Oh,
roads or gardens.
could be, yeah. And what's interesting is the distinction between community schemes and community strata schemes.
Okay, tell me about that.
So in a community scheme, your lot boundaries are usually defined by surveyed land. You own the actual ground and the buildings on it. Think like houses on separate bits of land, but maybe sharing a driveway or facilities.
Got it. So you own the dirt and the house, but share some infrastructure. What about community strata schemes then? How's that different for ownership?
Community strata is more about shared buildings. Here, the common property includes parts of a building, and your lot is defined by the physical structure itself.
Like the inside of your apartment.
Exactly. Usually the internal surfaces of your walls, floors, ceilings, unless the plan says something different. So you own the airspace within those defined limits.
Ah, okay. And that difference must affect who fixes what, right? Maintenance, insurance?
Absolutely. It directly impacts who's responsible for upkeep and who needs to insure what parts.
Makes sense. So if you're thinking about buying into a community title, what's the absolute number one thing you need to consider before signing anything?
Due diligence, 100%. It is so critical. Because when you buy into one of these, you're not just buying the property itself. You're becoming a member of this thing called a community corporation.
Which comes with responsibilities.
Exactly. Responsibilities and potentially liabilities. So
Right.
before you commit, you have to get as much info as you can about its finances, its rules, the whole setup.
And the law helps with that, getting the info.
Yes, the Land and Business Sale and Conveyancing Act and its regulations actually requires vendors to give you crucial information about that specific community title. And they have to do it at least 10 clear days before settlement.
10 days, okay.
It's designed to make sure you understand what you're stepping into.
And what sort of crucial info are we talking about in that disclosure?
Well, the regulations provide a specific checklist. It's called Matters to be Considered in Purchasing a Community Lot or Strata Unit.
Okay, that sounds useful.
It really is. It flags the obligations, the restrictions.
Yeah.
It basically says, hey, look carefully at this stuff, get legal advice if you're unsure, before you're locked into a contract.
Right. Okay, so you've done the homework, you've bought the place, now you're part of this community corporation. What does it actually do?
So the corporation just pops into existence legally as soon as the community plan is lodged.
Automatically.
Automatically. Its main job is to manage and administer the whole scheme according to its bylaws and the act.
Which includes looking after that common property we talked about.
Precisely. Driveways, gardens, pools, whatever is shared. And the members. That's just every single owner of a lot within the scheme, automatically members.
Okay.
And here's a really important point. Lot owners are effectively guarantors for the corporation's debts.
Whoa, hang on. So if the corporation owes money.
Creditors can potentially pursue the individual lot owners for their share.
Yeah, okay, that's definitely something you'd want to factor in financially. Wow. What about the day-to-day upkeep? The shared bits?
That's the corporation's job too, managing and maintaining the common property.
And how do they pay for that?
They usually have to set up and maintain two funds: an administrative fund for regular stuff like insurance, mowing, cleaning,
The ongoing costs.
right, and a sinking fund for bigger future capital works, like repainting the whole building, replacing the roof, major infrastructure.
Planning ahead. Makes sense.
Although there's an interesting exception. If it's a really small scheme, just two lots.
Like a duplex kind of setup.
Exactly. They can actually decide in their bylaws that they don't need those formal funds.
Ah, streamline for the small ones.
Yeah.
Okay. What about your own place, your individual lot? Who maintains that?
The general rule under the Act is that you, the lot owner, are responsible for maintaining and repairing your own lot.
Okay.
But, and this is important, the bylaws for your specific scheme can change that. They could shift some or all of that responsibility onto the corporation.
So you really need to check those bylaws.
Absolutely.
Yeah.
And if the responsibility is with the owner and they don't do the required maintenance, the corporation can step in. They can issue a written notice demanding the work gets done by a certain date. And they can even enforce necessary work if there's a breach of the Act or the bylaws.
Even if the problem was caused by a previous owner.
Yes, potentially.
Yeah.
The obligation can attach to the lot.
So if my neighbor's roof, say, is falling apart and looks dangerous, the corporation might be able to force them to fix it.
Potentially, yes.
Hmm.
If it affects common property or breaches bylaws, and if the work isn't done after they give notice, the corporation actually has the power to send workers onto the lot to do the repairs themselves.
Can they just walk in?
No. They have to give at least 2 days written notice to the owner and any occupier, like a tenant.
Okay.
And actually forcing entry usually requires a magistrate's court order, unless it's a genuine emergency like immediate danger or risk of serious damage.
And who pays for that work the corporation does?
The lot owner becomes liable to the corporation for the reasonable costs, although the owner might then be able to recover those costs from whoever was actually responsible, like maybe a tenant who caused the damage.
What if the corporation needs access for something essential? Like, a shared water pipe runs through my backyard and needs fixing.
Right. In those situations, the corporation has a legal right to enter a lot to install, maintain, or repair essential service infrastructure.
Do they still need to give notice?
Yes, they have to give reasonable notice beforehand. What's reasonable depends on the situation. Urgent repairs might mean less notice is reasonable.
Got it. Transparency seems key in these setups. What kind of info and documents can owners actually get access to?
Owners and also mortgagees or potential buyers have pretty good access rights. You can ask to see the corporation's insurance policies they have to provide those free of charge.
Okay.
You also have the right to inspect other key documents without charge, like contracts with the strata manager and the register of all the lot owners.
What about finances and meeting minutes?
Owners can inspect those for free too. Mortgagees and potential buyers might have to pay a regulated fee for inspection or copies. And a corporation has to keep records notices, minutes, letters for set periods, sometimes up to 30 years.
Now, we hear about bylaws a lot in these community living things. How do they work under the Community Titles Act? Is it different from, say, strata?
Yes, this is a significant difference from the older strata title system. The Community Titles Act doesn't just give you a standard set of bylaws.
No.
No. The developer of each specific community scheme actually has to draft their own unique set of bylaws.
Tailored to that specific development.
Exactly. They have to cover administration, use of common property, use of the individual lots, and it all has to align with the scheme's overall description.
And are there limits on what these bylaws can say?
Yes, definitely. They can't prevent an owner or occupier from having reasonable access to their own lot. That's fundamental.
Makes sense.
And importantly, they also can't prohibit people with disabilities from having and using assistance animals or therapeutic animals. That's protected.
Okay. What if someone doesn't follow these bylaws? Are there consequences? Penalties?
Yes, the bylaws themselves can actually set out penalties for breaches.
Fines?
Usually fines, yes. If an owner or occupier gets a penalty notice for supposedly breaking a bylaw, they have 60 days to apply to the magistrate's court to challenge it, to ask for it to be revoked.
And then the corporation has to prove the breach.
That's right. The onus shifts to the corporation to convince the court that the breach likely happened. And while the court is considering it, you don't have to pay the penalty.
Okay. Let's talk about how decisions get made. Meetings, voting. What are the rules?
Right, so every general meeting has a mandatory agenda. It has to include the exact wording of any big resolutions, unanimous or special ones, and the reasons for them. Plus, standard stuff like confirming the minutes of the last meeting.
What about the very first meeting?
The first statutory meeting has extra requirements, like appointing the initial office holders and approving the first budget.
And voting itself. How does that work? Can you vote if you're not there?
Yes, you can do absentee voting. You just give written notice before the meeting. And anyone at the meeting can demand a written ballot instead of just a show of hands.
What if a property is owned by more than one person?
They can nominate one person to vote for that lot. And they could even attach conditions to that nomination.
Interesting.
And there are specific rules for small schemes. In a two-lot scheme, if one owner votes against something, it's automatically defeated.
Just one no vote kills it.
In a two-lot scheme, yes. And for three-lot schemes where everyone has one vote, a special resolution passes as long as no more than one person votes against it.
Okay. You mentioned different types of resolutions, ordinary, special, unanimous. What's the difference in how many votes they need?
Good question. An ordinary resolution is the basic one. Simple majority, more than 50% of the votes cast by eligible people present or voting by proxy.
Okay, standard majority rule.
Right. Special resolutions have a higher bar. You need at least 14 days written notice with the exact wording and reasons. And crucially, it's not just a majority of those voting, it usually requires support from a certain percentage of those entitled to vote, often representing a majority of the total lot entitlements. The exact requirements can vary slightly depending on what the resolution is about.
And unanimous. That sounds like everyone has to agree.
Pretty much. Unanimous resolutions are for the really big things, like changing the lot entitlement schedule, which affects how much everyone pays in contributions, or fundamentally changing the description of the community scheme itself.
What if you need a unanimous vote, but you can't get everyone on board? Is it just stuck then?
Not necessarily.
Mm-hmm.
If you need a unanimous resolution but only get, say, enough votes for a special or even just an ordinary one, the corporation or anyone who voted for it can apply to the magistrates or district court.
To ask the court to approve it anyway?
Essentially, yes. To ask the court to declare the resolution legally sufficient despite not reaching unanimity.
Right. What about the management committee? Who serves on that, and what do they do?
The management committee is elected by the owners at the AGM each year. Their term usually lasts until the next AGM, but they can be reelected.
And how do vacancies get filled if someone leaves midterm?
Vacancies happen for various reasons. Someone resigns, sells their lot. The remaining committee members have the power to appoint another eligible person to fill that spot until the next AGM. That's called co-opting.
And can the owners remove a committee member?
Yes, the corporation can remove a committee member by an ordinary resolution, usually if there are good reasons like misconduct or neglect of duty.
Okay. How are the finances managed beyond those admin and sinking funds we mentioned earlier, particularly for bigger schemes?
Right, so for larger corporations, say, between 7 and 20 lots, with common property insured for $100,000 or more, they have to prepare a forward budget or sinking fund budget each year.
Looking ahead.
Exactly. It has to outline the expected non-routine spending over the next 3 years. And they need to update that forecast every 3 years.
And for even bigger ones.
If there are more than 20 lots and similar insurance levels, that forward budget has to look ahead 5 years and be updated every 5 years.
And small ones are exempt.
Yes, those with 6 or fewer lots or where the insured common property is less than $100,000 generally don't have this specific forward budgeting requirement.
We touched on disputes over bylaws. What about other disagreements? Neighbors arguing, maybe? Or disputes with the corporation itself?
Mediation is really pushed as the first step. It's usually much better for keeping the peace than jumping straight to court.
How does mediation work here?
It's voluntary. A trained, neutral mediator helps the people involved talk things through and try to find their own solution. It's confidential and aims for an agreement everyone can live with.
But if mediation doesn't work or isn't suitable?
Then various parties, the corporation, owners, even potential buyers can apply to the magistrate's court. These are usually handled as minor civil actions.
And the court can make orders.
Yes, significant powers. They can order people to do things or stop doing things, demand information, order audits, rule on bylaws, even reverse corporation decisions if they are unfair or oppressive.
Wow.
And failure to follow a court order can bring hefty penalties.
Is it possible for the whole corporation management to just collapse?
In really extreme cases, yes. If the governance completely breaks down, the magistrates or district court can appoint an external administrator to take over.
We also saw a quick mention about converting other types of titles to community title. Is that common?
Existing strata schemes can convert to become community strata schemes. It needs an ordinary resolution by the strata corp.
Does that change the boundaries?
No, not automatically. The old strata articles just become the new community bylaws, though they can be changed later. Other types, like company titles, can also apply to convert, but they might need to do upgrades to meet current building standards first.
The source also had a common questions bit. What are some key things potential buyers should be checking?
Yeah, that section flags some crucial due diligence points. You should definitely compare the contributions, the levies, with similar properties.
See if they're reasonable.
Exactly. Also, find out if there are any unpaid contributions on the specific lot you're looking at. You could inherit that debt.
Ouch. Okay.
Ask about any big planned spending. Check for known structural issues. See if the sinking fund looks healthy enough for future repairs.
What about management?
Understand the maintenance services, the costs, who the manager is, how disputes are usually handled. If it's a two-lot scheme, check if they've opted out of things like AGMs or having formal funds.
Lifestyle rules too. Parking, visitors.
Yes, and accessibility. And a key point for standard community titles, not strata. Tree issues between neighbors are usually just between those neighbors, not the corporation's problem.
Right. And water rates. That can be tricky in shared living. How's that usually handled?
SA Water has a few billing options. One bill to the corporation, or divided equally, or divided based on lot entitlement.
Who decides?
Well, the corporation is ultimately responsible for the whole bill. If they want to charge everyone an equal share, but the lot entitlements aren't equal, they generally need a unanimous resolution to do that.
Otherwise, it's based on entitlement.
Usually, yes.
Yeah.
Or owners can install their own private meters, but that costs money.
Right. Okay. That's a really detailed look at community titles.
Mm-hmm.
Let's pivot now to something we hope not to deal with too often, court and tribunal fees. We've got a guide from the Legal Services Commission. What's the main point here?
The core message is really twofold. First, it outlines the fees you might face in different courts and tribunals in SA federal and state.
Okay.
But second, and maybe more importantly, it explains how you can apply to get those fees waived or reduced if paying them would cause you real financial hardship.
So it's about access to justice, not letting fees be a total barrier.
Exactly. That's a vital aspect. And the guide includes the latest court rule update, so it's current.
There's some specific jargon here. What's a key term we should get?
Registrar, that's important. In this context, a registrar is a court officer who has the power to actually make the decisions on those fee waiver applications.
Okay. So say someone needs a fee waived in a regular SA court. What's the process?
You need to fill out a specific form, Form 76A. You can get it from the court registry or download it.
Can you do it online?
Interestingly, at the time the guide was written, this particular form could be lodged online via the Court SA portal. You had to physically lodge it at the registry.
Okay, paper form. Then what?
The registrar looks at it. They might ask for more information, proof of your financial situation.
Like bank statements or something?
Could be, yeah. Then they notify you of their decision waived, reduced, or denied.
What if the registrar isn't sure?
They can actually refer the application up the chain, usually to a master of the court, for direction or a decision.
And you can challenge the registrar's decision.
Yes, but you have to be quick. You only have 7 days from when you get the decision to seek a review. There are specific forms for that, too. Form 182 or 183, depending on the type of document fee. The court then reviews it.
What about specific tribunals, like the South Australian Employment Tribunal, SAET? Different process.
Yep, different form there, Form P16, which you get from the SAET website. And in SAET, the registrar also sets fees for things like hearing transcripts, interpreters, copying documents, witness costs. So always check the SAET website for current fees.
Okay, so there's a process. But what's the actual basis for getting a waiver? What do they look at?
The main principle is fairness and avoiding hardship. The registrar looks at your whole financial picture: income, assets, essential living costs, debts.
To see if paying the fee would genuinely hurt you financially?
Exactly. Would it cause significant financial hardship? That's the test. One specific point for family law in SA. These hardship waivers are only for individuals, not companies. And if you get one waiver, you need to apply again for any later fees in the same case.
What about the federal court? Similar idea of financial hardship.
Yes, very similar. The federal court has guidelines, especially for family law, on their website. If you don't meet the general exemption criteria, you can apply for a waiver, based on financial hardship.
Same assessment. Income, assets, expenses.
Pretty much the same factors. But for the federal court application, you need to provide comprehensive evidence and also a formal affidavit, sworn or affirmed before a JP or lawyer.
Affidavit. Okay.
And they also offer the possibility of deferring fee payments, but that's a separate application.
Are there any groups who automatically get a reduced fee in federal court, maybe not a full waiver?
Yes, there's a reduced fee category. It's a flat $100 fee for certain people.
Who qualifies for that?
People on legal aid, Commonwealth concession card holders, prisoners, people under 18, those getting youth allowance, AUSTUDY or AB study, and also people getting assistance under the Native Title Act.
Okay. And lastly on fees, the Administrative Appeals Tribunal, the AAT.
The AAT has standard application fees varying by case type. There's a specific fee for reviewing small business tax decisions.
Any reductions there?
Yes. Same $100 reduced fee for legal aid recipients and concession card holders. And interestingly, in some refugee cases, if the AAT makes a decision more favorable to the applicant, the fee might get waived or refunded.
What about migration reviews?
Migration review fees at the AAT are generally higher, and waivers are much more limited.
Right. That's super useful on navigating the cost side of the legal system. Let's move into a very personal and sometimes legally complex area, de facto relationships. What's the basic legal definition we need to grasp?
Okay, the core definition, legally speaking, is two people living together as a couple on a genuine domestic basis who aren't legally married to each other.
And that includes same-sex couples.
Absolutely. It applies regardless of sex or gender identity. The crucial thing isn't just sharing a house or having a sexual relationship. The law looks for a genuine commitment, a mutual intention to live together as a couple.
Is there different terminology used sometimes?
Yes, South Australian state law often uses the term domestic partnership, whereas Commonwealth law mainly talks about de facto relationship. They generally mean the same thing in practice.
Do you need to register or get a court declaration to be recognized?
For most legal purposes, no. Once you meet the criteria, living together as a couple for a certain period, usually 2 years, or having a child together, the law often recognizes the relationship without formal steps.
But sometimes a declaration is needed.
Yes, particularly if there's doubt, or crucially, if the relationship lasted less than 2 years, wasn't registered elsewhere, and there's no child. In that specific case, you might need to apply to the court under the Family Relationships Act for a declaration if it's in the interest of justice.
What about protecting your finances in a de facto relationship? Can you make agreements beforehand, like a prenup for married couples?
Yes, absolutely. Under the Family Law Act, de facto couples can make legally binding financial agreements.
When can you make these?
Before, during, or even after the relationship ends. They can set out exactly how assets and finances will be divided if you separate.
What makes them legally binding?
They have to be in writing, signed by both partners. And crucially, each person must get independent legal advice from their own lawyer before signing.
Separate lawyers.
Yes, essential. And the lawyers then provide statements saying they gave that advice, and those statements get exchanged.
Can these agreements ever be overturned?
The court can set them aside, but only in limited situations.
Yeah.
Like if someone didn't disclose major assets, or there was fraud or duress, or the terms are just completely unfair, unconscionable.
If a de facto relationship ends and there's a fight over property or money, can the court step in?
Yes, but certain conditions usually need to be met.
Like what?
Generally, the relationship needed to be registered somewhere with a register, though SA doesn't have one generally, or last at least 2 years, or there's a child of the relationship. Or if one partner can show they made substantial contributions and would suffer a serious injustice if the court didn't make an order.
Is there a time limit to apply to court?
Yes, a strict one. You generally have 2 years from the date of separation to file for property or maintenance orders unless the court grants special permission.
And which court handles these disputes?
It's the Federal Circuit and Family Court of Australia. And importantly, they apply the same legal principles as they do for married couples splitting up.
So no automatic 50-50 split.
Definitely not. The court looks at contributions, financial and non-financial future needs, fairness, a whole range of factors.
What about kids? If a de facto couple separates, is it handled differently legally than if they were married?
The absolute guiding principle for children is always their best interests. That's paramount, regardless whether the parents are married or de facto.
So the process is similar.
Yes. Parents are encouraged to agree on arrangements themselves, often using mediation or family counseling. In fact, attempting mediation is usually required before you can go to court for parenting orders, unless there are safety issues.
And if they can't agree?
Then either parent can apply to the court for parenting orders, and the court decides based on the child's best interests, using exactly the same legal principles as for children of married parents.
And finally, child support. Does that apply to de facto couples too?
Yes, the obligation is the same. The parent who has the main care of the child is entitled to receive child support from the other parent.
What if parentage is disputed?
Legal advice and potentially parentage testing would be needed. The Family Law Act also allows separated parents in same-sex relationships to apply for child support from a recognized co-parent.
And Centrelink might get involved.
Yes, Centrelink might require parents to apply for a formal child support assessment as part of getting certain benefits.
Okay, that gives us a really solid understanding of de facto relationships legally. Now, we notice there's a whole separate fact sheet just called debts. That sounds significant.
It definitely suggests it's a major area with its own set of rules and complexity.
Right.
The fact that the Legal Services Commission has a dedicated resource just on debts really highlights how important it is under SA law. While we don't have the specifics from that fact sheet here today, you'd expect it to cover things like your rights when you owe money, what creditors can and can't do, options for managing debt, bankruptcy maybe, and where to get help.
So, a crucial topic, but one for potentially another deep dive using that specific resource.
Precisely. It underscores the importance of understanding your position if you're dealing with debt.
Fair enough. Let's move to an area with very immediate and frankly serious legal consequences. Drink driving. We've got the SA fact sheet here. What are the main offenses?
Okay, there are two main ones. Driving over the prescribed concentration of alcohol, that's PCA, and driving under the influence, DUI.
Which is more common?
PCA is charged much more often. It's based purely on your blood alcohol content, your BAC, being over the limit. DUI is more serious and requires proof that your actual driving ability was impaired by alcohol.
Okay. What is the PCA limit in South Australia?
For drivers with a full unrestricted license, the limit is 0.05. So 0.05 grams of alcohol per 100 milliliters of blood.
And for L platers, P platers?
Zero. Absolutely zero tolerance. Learners, provisional drivers, P1 and P2, and anyone on a probationary license must have a BAC of 0. Any alcohol detected is a breach of their license conditions.
And if they do have a BAC of 0.05 or more?
Then they get charged with the PCA offense as well as the breach of condition penalties. Double whammy.
And does it matter if you feel okay to drive?
Nope. The PCA offense is purely about the number. Doesn't matter if you felt fine or thought your driving was perfect. Over the limit is over the limit.
We also see mention of much more serious charges if a child is in the car.
Yes, that's a significant aggravating factor. Driving with a BAC of 0.08 or more, or being incapable of proper control, DUI, while a child under 16 is in the vehicle is a much more serious offense.
Harsher penalties?
Definitely. Longer disqualifications, bigger fines. And crucially, if convicted of that, you must undergo an alcohol dependency assessment before you can even apply to get your license back.
What about being breath tested? What are the police powers?
They're pretty broad in SA. Police can do random breath tests anywhere, anytime. All operational police cars are equipped for it now.
So not just at booze buses?
No, any police car could potentially test you. They could test you if you're driving, or even up to 8 hours after you drove or tried to drive.
Wow, 8 hours?
Yes. For random tests, the officers need to be in uniform, using a marked car or one with flashing lights or an alarm.
What if you refuse a test?
That's a serious offense in itself. Refusing a lawful breath or blood test carries penalties similar to high-range drink driving. You can't just say no.
If someone gets caught for the first time, PCA, what sort of penalties are they looking at?
For a first PCA offense, you're typically looking at a license disqualification period, a fine, and demerit points. The severity, how long the disqualification, how big the fine generally increases with how high your BAC reading was.
And driving while disqualified, what happens then?
That's treated very seriously. Driving while your license is disqualified is a criminal offense.
Penalties.
Can be substantial. Much higher fines than the original offense, potentially jail time, and a further, often longer disqualification period. Especially the original disqualification was for a serious drink driving offense or involved a child passenger.
And getting your license back afterwards isn't automatic?
No. After disqualification, you typically have to go on to a probationary license for at least 12 months. Strict conditions apply: 0 alcohol, carry the license always, very few demerit points allowed. Breaching those conditions can lead straight back to disqualification.
Finally, on drink driving, should people get legal advice? even if they plan to plead guilty.
Yes, it's highly recommended. Even for a guilty plea, legal aid might only be available if jail is likely at 12, which is more common for DUI, repeat offenses, driving while disqualified, or very high readings, especially with a child involved.
But a lawyer can still help.
Definitely. They can explain the likely penalties, help you present your case in the best light, highlight any mitigating factors. If you represent yourself, you need to be ready to explain what happened, what you're doing to stop it recurring, and your personal financial situation.
And if pleading not guilty.
Absolutely essential to get legal advice then. Understand the evidence, your chances. The Legal Helpline from the Legal Services Commission is a good first point of contact for free initial advice.
Right, that's sobering but vital info. Let's switch to the related issue, drug driving. What's the basic law here in SA?
The core offense is driving or trying to drive with a prescribed drug present in your system.
Which drugs are prescribed for the roadside tests?
Currently, the saliva tests use roadside detect THC from cannabis, methamphetamine, like speed or ice, and MDMA, ecstasy.
And is there a minimum amount, like the 0.05 for alcohol?
No, this is a critical difference. For these prescribed drugs, any detectable amount is an offense.
Wow. So even trace amounts?
Yes. And because these drugs can stay detectable in saliva for hours, sometimes even days, after use, any presence while driving is enough for a charge.
Are there similar, tougher penalties if a child is present, or for repeat offenders?
Yes. Similar principles apply. If you're convicted of drug driving with a child under 16 in the car, or if you have other drug driving convictions within the last 5 years,
Then what?
you'll be required to undergo a drug dependency assessment before you can get your license reissued after the disqualification ends.
What are the penalties for a first-time drug driving offense?
For a first offense, there's a mandatory minimum disqualification period. The court can impose longer if it wants, plus a fine and demerit points.
And worse for repeat offenders?
Significantly worse, yes. And if you're a P-plater or L-plater, you could face extra penalties for breaching license conditions on top of the drug driving penalties.
That drug dependency assessment, is it similar to the alcohol one? Purpose process?
Yes, very similar purpose.
Yeah.
It's required in those specific circumstances, child present or prior convictions, to see if there's an underlying drug dependency issue contributing to the offense.
Who pays for it?
The driver pays for the assessment
Mhm.
and also for any treatment programs that are recommended as a result. And you generally won't get your license back until you can show you're not dependent.
What about getting your license back after a drug driving disqualification? Is it automatic once the time is up?
No, same as drink driving. The license is canceled, not just suspended.
So you have to reapply?
Yes, you must actively apply to renew your license after the disqualification ends. Driving during the disqualification is a serious offense with potential jail time, more fines, longer disqualification.
And driving after the disqualification ends but before you've renewed?
Still an offense. The penalties depend on how serious the original drug driving charge was.
Right, really underlines the need to follow the rules there. Let's shift gear completely now to a different kind of legal tool. The enduring power of attorney, or EPA. What's the main point of having one of these?
An EPA is a really vital document. It lets you appoint someone you trust, they're called the donee, or attorney, to make financial and property decisions for you.
Okay.
The key word is enduring. It means the power continues even if you later lose the mental capacity to make those decisions yourself, maybe due to illness or an accident.
So it's different from a regular power of attorney.
Yes, a general power of attorney stops being valid if you lose capacity. An enduring one keeps going.
Once an EPA is set up, can anyone else challenge it or get it revoked?
Yes, there are safeguards. If someone, family, friend, anyone with a genuine interest has concerns about how your attorney is handling your finances, they can apply to SACAT, the tribunal,
To do what?
to potentially have an administrator appointed instead of the attorney. Also, the Supreme Court can revoke an EPA if, say, it turns out you didn't have capacity when you signed it, or if the attorney is acting improperly or not in your best interests.
How do you actually create a valid EPA in SA? What's the process?
The standard way is using the official form P2. You fill that out, make a certified copy for each attorney you appoint.
And witnessing, that's important.
Absolutely crucial. It needs one witness, over 18, who knows you personally. And that witness cannot be one of the attorneys you're appointing, or related to them, or closely associated.
And the witness confirms you understand it.
Yes, the witness has to certify they believe you understood what you were signing and its effect.
What if you change your mind later? How do you cancel an EPA?
If you still have legal capacity, You can revoke it. You use another official form, Form RP Revocation of Power of Attorney.
Can that revoke both types, general and enduring?
Yes, but again, only if you have the capacity to understand what you're doing.
What's the process then? Just fill out the form.
You fill it out, get it witnessed correctly, then it's vital you formally notify your attorneys in writing that their power is revoked. Sending them a copy of the signed Form RP is the best way.
What if the original EPA was registered somewhere, like with land titles?
Then you also need to lodge the revocation form, Form RP, with Land Services SA. There's a fee for that.
And tell banks and others.
Definitely. Tell anyone involved in your finances, banks, share registries ASAP, because actions taken by the attorney are legally binding until they get notified of the revocation.
Okay. Any final checks when doing the revocation form?
Just make sure your name and address are correct, the witness is signed, and put their details, and if you made any changes on the form, both you and the witness initial them.
Got it. That's a clear rundown on EPAs. Let's move into another big, complex area, family law. We have a Legal Services Commission booklet here. What's its main aim?
This booklet is really designed as a starting point. It gives basic family law info and some guidance if you're thinking about legal action.
But it's not legal advice itself.
Absolutely not. It stresses that family law is complex, always changing. So the booklet strongly advises getting specific legal advice for your own situation. Think of it as an introductory guide, not the final word.
What's the main law governing things like divorce, kids, property splits, and essay, and which courts deal with it?
The main federal law across Australia is the Family Law Act 1975. That covers divorce, parenting matters, and property disputes.
And the court in essay.
It's the Federal Circuit and Family Court of Australia. That's where most of these matters are heard.
But do state courts ever get involved in family-related things?
Yes, sometimes. SA courts and tribunals like the Magistrates Court, Youth Court, and SACAT handle things not covered by the Family Law Act, like some property disputes, intervention orders for violence, child protection, name changes, wills, that sort of thing.
The booklet really emphasizes reaching agreement. Why is that so important in family law?
The Family Law Act itself pushes people towards resolving things out of court. There's actually a legal duty in many cases to make a genuine effort to sort things out before you litigate.
How? What's the main way?
Family Dispute Resolution, or FDR. It's presented as cheaper, quicker, and less stressful than court battles.
Where do you find FDR services?
There are community-based ones, private ones. You can find services listed online, like at familyrelationships.gov.au. And for parenting disputes, attempting FDR with a registered practitioner is usually compulsory before you can file in court, unless it's unsafe.
Do the FDR practitioners give legal advice?
No, they're neutral facilitators. They help you talk but don't advise you legally. That's why getting your own independent legal advice before and during FDR is still really important.
When does FDR work best?
When both people feel safe, can negotiate fairly, and there isn't a huge power imbalance. It might not be suitable if there's been violence or one person feels intimidated.
The booklet also strongly suggests getting lawyers involved. Why is that so crucial in family law?
Primarily so you actually understand your rights and obligations under the law and how it applies to your case.
And they help explore options.
Yes, including ways to settle out of court. They can advise on likely court outcomes, help prepare your case, and critically, review any agreement before you sign it to make sure it's fair and legally sound.
Can you change lawyers if you're not happy?
Yes, you have the right to change, but be aware that if you owe your old lawyer money, they might hold on to your file until the bill is paid, which can cause delays.
Legal costs are a big worry. What about legal aid for family law? Is it free?
The booklet clarifies it's not usually free in SA for family law. You'll likely have to pay a contribution based on your finances.
Even if you don't have much cash?
Yes, especially if you own property. Even if it's not easily sellable, you might have to repay the legal aid later, say, when the property is sold or your financial situation improves.
Is there any free help available?
The Legal Services Commission has the free legal helpline. That can give preliminary info, basic advice, and referrals, including to legal aid if you might be eligible. But it's usually just initial guidance.
What specific types of cases does the Family Law Court, the Federal Circuit, and Family Court actually handle?
A wide range. Divorce applications, obviously. Parenting orders about where kids live, who they see, enforcing orders if someone breaches them. Parentage disputes, spousal maintenance, child maintenance, and property settlements for both de facto and married couples after separation.
Do you have to pay to file these applications?
Yes, most applications have filing fees. But as we discussed earlier, waivers or reductions are possible if you have a concession card or can show financial hardship.
Is it okay to handle simple things yourself, like an uncontested divorce?
Potentially, yes. But for anything more complex, especially involving kids or significant assets, getting legal help is really strongly recommended.
Let's talk about the start of the process, separation. What legally happens when a couple separates?
Legally, separation is when you stop living together as a couple with the intent to end the relationship. This might mean one person moves out, or you live separate lives under the one roof.
Do you need to file paperwork to be legally separated?
No, not usually. Unless you were in a formal registered relationship, less common in SA for heterosexual couples, there's no official form or notification needed just to mark the date of separation.
But you need to tell Centrelink.
Yes, definitely. You have 14 days to notify them, as it affects payments.
What about the house? Can one person kick the other out?
Not without a court order. After separation, both partners generally have a right to live in the family home, regardless of whose name is on the title. You can't legally force someone out without a court order.
What if you choose to leave? Does that affect things?
It might. Leaving the home could potentially impact your relationship with children or future property negotiations, so it's something to consider carefully and possibly get advice on.
Okay, what about getting a divorce? What's the legal basis for it in Australia?
The only ground for divorce is the irretrievable breakdown of the marriage.
How do you prove that?
You need to show the court you've been separated for at least 12 continuous months right before you file the divorce application, and there's no reasonable chance you'll get back together.
Does it matter whose fault it was?
No. Australia has no-fault divorce. Fault isn't relevant to getting the divorce itself. And it doesn't matter if one person doesn't want the divorce if the conditions are met. It can usually be granted.
Does the divorce sort out kids and property too?
No, that's a common misconception. The divorce order just legally ends the marriage. Arrangements for children and dividing property are separate issues, needing separate agreements or court orders.
What if you've been married less than 2 years?
There's an extra step. You usually need to provide a counseling certificate showing you've attended marriage counseling or get the court's permission by showing special circumstances.
What if you don't know where your ex is? Can you still get divorced?
Yes, it's possible, but more complicated. You'll likely need legal advice and might have to apply for substituted service or ask the court to dispense with service altogether.
The divorce application asks about kids, right? Does that create orders?
It asks about the current arrangements for kids under 18, living, time with parents, support, health, education. The court considers this, but the info you put in the divorce application doesn't automatically become legally binding parenting orders. That's a separate application if needed.
Moving on to children after separation, what's the absolute #1 principle?
The child's best interests, always. That's the paramount consideration in every decision, whether it's in a parenting plan or a court order.
Let's talk parenting plans. What are they exactly?
A parenting plan is a written agreement voluntarily made and signed by both parents after separation. It sets out the arrangements for the kids.
What kind of arrangements?
Where they live, how much time they spend with each parent, schooling, holidays, health decisions, religion, pretty much anything relevant to their care and well-being.
Are they legally enforceable, like court orders?
No, not in the same way. Their advantage is providing clarity between parents, but they aren't confidential like mediation discussions.
Do courts look at them if there's a dispute later?
Yes, they can be very influential. A court will often consider a previous parenting plan as evidence of what the parents themselves thought was best for the child at that time. If parents later disagree and want to change things, they either need a new plan or one can apply for court orders.
So if parents can't agree and need the court, what are parenting orders and what does the court look at?
Parenting orders are legally binding orders made by a judge or judicial registrar. They specify who the child lives with, spends time with, parental responsibility, communication, etc.
And the deciding factor is still best interests.
Always. The Family Law Act lists factors the court must consider. Things like the child's views, though usually heard indirectly, protecting the child from harm, the child's relationship with parents and others, practicalities, parents' capacity, any family violence history.
Does the court prefer any particular outcome?
There's a preference for orders least likely to drag everyone back to court, and generally there's a presumption of equal shared parental responsibility.
What does that mean? 50-50 time?
No, not necessarily. It means parents should consult on major long-term issues, like schooling, major health decisions. But this presumption doesn't apply if there's violence or it's not in the child's best interests. It definitely doesn't mean equal time automatically.
How does the court find out the child's views or what's best?
Through evidence from witnesses. Or they might appoint a court child expert to write a report, like a child impact report. In really complex cases, an independent children's lawyer might be appointed to represent the child's interests directly.
What's the actual court process for getting parenting order?
Well, first, remember that requirement to try FDR. You generally need to file proof you've done that, a Section 60I certificate, or explain why you haven't, e.g., safety.
Okay, what else do you file?
An initiating application, a supporting affidavit setting out the facts, a parenting questionnaire, and sometimes a specific notice if there are allegations of abuse or risk.
Then what happens in court?
It often starts with an interim hearing for urgent issues. Then directions for dispute resolution, maybe with a court child expert. If that doesn't work, it moves towards trial compliance and readiness hearing, maybe a trial management hearing, then the final hearing where a judge makes the decision.
How long does it all take?
The court aims for about 12 months from filing to final resolution, but complex cases can take longer. Urgent safety cases might get prioritized.
You mentioned court child experts. What do they actually do?
They're trained professionals, psychologists or social workers specializing in children and family separation issues.
Is what you tell them confidential?
No, absolutely not. Anything you say to them can be reported back to the court. Their role is to help parents resolve disputes if possible, provide information to the court, write memos, and sometimes make recommendations about what's best for the child.
What if one parent wants to move away with the child? Relocation.
Big issue. Even if there are no current court orders, a parent should always get legal advice before moving a child to another region or state without the other parent's agreement, because the court can intervene. If the court decides the move isn't in the child's best interests, it can stop the move or even order the child be returned. Communication and agreement or court orders are key here.
The booklet also mentions child support, parentage, and changing assessments. What are the key takeaways there?
For detailed advice, the Legal Services Commission has a specific child support helpline that's the best resource.
Okay.
But basically, child support relies on establishing parentage. If that's disputed, DNA testing can resolve it. You can apply to Services Australia Child Support to have an existing assessment reviewed or changed, sometimes even retrospectively for up to 18 months. Longer needs a court application. Again, the helpline can advise on this.
What about child support agreements? Are they an alternative to the government assessment?
Yes, parents can make private written agreements instead of using the standard formula.
What can these agreements cover?
Periodic payments, non-cash things like paying school fees direct, or even lump sums, though only periodic payments can usually be collected by Services Australia.
Is legal advice needed for these?
Absolutely crucial before signing anything. An agreement made under pressure might not be valid. There are different types, limited and binding agreements, with binding ones being harder to end. Be aware these agreements can also affect your family tax benefit.
What about adult children and child support? Does it always stop at 18?
Not necessarily. If a child turns 18 but is still in full-time secondary school, the assessment can potentially be extended to the end of that school year. But you need to apply to Services Australia before their 18th birthday. Not doing so can affect family tax benefit too.
What if one parent pays bills directly, like school fees or medical costs? Can that count towards child support?
Sometimes. If Services Australia is collecting the support and the paying parent has less than 14% care, certain direct payments, education, essential medical, dental, maybe accommodation costs for the other parent can sometimes be credited. Often needs agreement, though.
Okay, let's shift to property after separation. What's the immediate practical advice?
First steps are financial protection. Tell your bank you've separated. Take steps to stop your ex running up joint debts, maybe close joint accounts, cancel redraw facilities.
And review important documents.
Yes, definitely review your will, superannuation beneficiaries, life insurance. If your name isn't on the house title but you think you have a claim, get legal advice fast about lodging a caveat to protect your interest.
How should couples go about reaching a formal agreement on dividing property?
Again, independent legal advice for both parties is key before signing anything. Make sure you understand it, that it's fair.
What does fair mean legally?
Generally, it aims to reflect what a court would likely order. That involves looking at the total assets and debts, contributions each person made, financial and non-financial like homemaking, and future needs of both parties. The final division must be just and equitable.
How do you make the agreement legally binding?
Two main ways: consent orders filed with the court or a binding financial agreement. Both provide finality and prevent future claims. And remember those time limits for applying to court if you can't agree.
Can you quickly explain consent orders versus binding financial agreements for property?
Consent orders are an agreement you both reach, which you then ask the court to formally approve and make into binding orders. There's usually a kit and a fee, though waivers are possible. Binding financial agreements are private contracts between you made before, during, or after the relationship. They have very strict rules, especially the need for independent legal advice for both sides with lawyer certificates.
The booklet also covers family violence intervention orders and family law injunctions. What's the difference and when are they used?
If you're experiencing family violence, get help immediately. Police, support services, legal services commission.
Does it have to be physical violence for an intervention order?
No. Intervention orders issued by state courts like magistrate's court can stop contact, someone coming near you, damaging property, harassment. Physical harm isn't required.
Yeah.
They can also order property be returned or allow one person exclusive use.
And family law injunctions.
These are orders made within a family law court case, federal circuit and family court. They might stop someone removing kids from the state, assault, entering the home, selling assets.
Which is better for immediate protection?
Often an intervention order. State police can enforce breaches of intervention orders directly and quickly. Enforcing a breach of a family law injunction has to go back through the family law court system, which can be slower.
Lastly, for family law, the booklet mentions wills again. Why is this relevant after separation or divorce?
Because separation and divorce have automatic legal consequences for existing wills.
Like what?
Marriage or entering a registered relationship automatically cancels any prior will, unless made in contemplation of it. Divorce or ending a registered relationship automatically cancels gifts or appointments, like executor, in favor of the former partner unless the will says otherwise.
So you need to update your will.
Absolutely. It's crucial to review and likely make a new will after separation, divorce, remarriage, or starting a new registered relationship to ensure your wishes are actually reflected legally.
Wow, that was an incredibly detailed run-through of family law. Let's switch gears to dealing with the aftermath of floods and insurance. We have a fact sheet on this. What's the first key resource mentioned?
The Australian Financial Complaints Authority, AFCA. It's highlighted right at the start.
Why is AFCA important?
It's a free, independent body that resolves complaints against insurance companies. If you're unhappy with your insurer's decision or handling of your claim, you can take your complaint to AFCA.
And their decisions matter.
Yes, their determinations are binding on the insurer. It's a powerful tool for consumers. But if you're still unhappy after AFCA, you'd need legal advice on other options.
Where else can people get info or help with flood insurance claims?
If the insurer's communication is confusing, the Legal Services Commission's helpline can assist. Your insurer must provide the Product Disclosure Statement, PDS, check their website, or ask for it.
What if you don't know who your insurer is?
The Insurance Council of Australia, ICA, can help you track that down. And the ICA's Understand Insurance website has heaps of general info, including specifically about flood insurance.
Okay, practicalities after a flood. What about cleanup?
Safety first, always. Don't start cleaning until you know it's safe. Think structural damage, electrical risks, contamination. The Red Cross has good advice on safe cleanup.
What about immediate cash needs? Can insurers help with emergency money?
Yes. If you tell your insurer you're in financial hardship, they have to tell you how to apply for support. Many can provide emergency funds quickly, sometimes within 5 working days for essentials.
And that gets deducted later.
Usually, yes, from the final claim payout. Same goes for emergency accommodation. If your home is unlivable, your policy should cover temporary accommodation, and the insurer should help arrange it.
Paying the excess can be tough after a disaster. Any flexibility there?
Often, yes. Insurers might let you pay it in installments or deduct it from the final claim. The fact sheet even have a sample letter you can use to ask for more time to pay due to hardship.
What if the damage is catastrophic? A total loss?
There's a total loss protocol. Generally, if the damage clearly exceeds your insured sum, the insurer shouldn't make you provide proof of ownership for every single item or detailed lists of everything lost.
Okay. How quickly should you expect a decision on your claim?
Once they have all the info they need, they should aim for a decision within 10 business days. If expert reports are needed, it might take longer, but generally shouldn't exceed 4 months unless there are really good reasons for delay. There's another sample letter if they're taking too long.
The booklet has some tips. What are the key ones?
If you're worried about structural damage, ask for a structural engineer's inspection. Worried about mold? Ask for a hygienist.
Good advice.
Also, if the repairers find more damage caused by the same disaster while they're working, the insurer generally has to cover that extra damage too.
Insurers sometimes offer cash settlements. What should you watch out for?
They might offer a lump sum to settle quickly. If other options exist, like repair place, they must give you a fact sheet explaining all options.
Should you just take the cash?
Be careful. Consider all future costs. Get independent advice if unsure. Once you accept a cash settlement, you usually can't claim more later, except maybe for hidden latent conditions.
And if you disagree with the insurer's final decision, what's the process?
First, complain to the insurer themselves. Ask for an internal review. They have to respond in writing within a set time frame.
And if you're still not happy after that?
Then you go to AFCA, the Australian Financial Complaints Authority. It's free, independent. They can look at delays, whether a claim should be paid, etc.
Got it. That's really helpful for navigating post-disaster claims. Let's move to another common situation, motor vehicle accidents. We have a step-by-step guide. What's the absolute first thing at the scene?
Injuries. If anyone is injured, even slightly, you must stop, help, call 00 for police and ambulance.
And report it.
Yes, if there are injuries, you also have to report it to your CTP insurer. You can find your CTP insurer details on the Easy Red website using your RIGO number.
Okay, safety first, then what? Practical steps.
Exchange details. Names, addresses, RIGO numbers, owner details if different. Give your details too. The booklet has an accident record card template for this.
What about towing?
There's a contact number for the accident towing roster in the booklet.
And police reports? When are they needed?
You must report to police if someone's injured, if there's significant property damage, or if the other driver failed to exchange details. The booklet explains how to get the report later if needed.
Let's quickly recap the types of car insurance in SA.
Okay. CTP compulsory third party is automatic with RIGO. Covers personal injuries you cause to others. Doesn't cover vehicle damage.
Then?
Third party property. Optional, but recommended minimum. Covers damage you cause to other people's car's property. Doesn't cover your car. Sometimes includes fire theft for extra cost. Maybe limited cover for your car if the other uninsured driver was at fault.
And the top level.
Comprehensive. Covers damage to your car, usually minus excess, regardless of fault, and damage you cause to others. Broadest cover.
The booklet mentions written-off vehicles. What does that mean?
It means the car's damage is so bad, repairing it costs more than its pre-accident market value.
Are there different types of write-offs?
Yes, statutory write-off means severe structural damage, unsafe, cannot be repaired or re-registered, ever. Only insurers can declare this. Repairable write-off means it can be repaired and re-registered, but only after passing a strict safety inspection, even if repair costs exceed market value.
And you can't just drive a written-off car.
No. Strict rules apply. Warning notices go on it, the registrar is notified, driving one is an offense, except for specific trips to repairs or inspection sites.
Okay, now say your car is damaged and you think it was the other driver's fault. Step 1 for making a claim.
Assess the damage. Get repair quotes, preferably too. If it's a write-off, get a valuation like Redbook for its pre-accident value and also a salvage value from a wrecker.
Step 2, after you have the costs.
Write to the other driver. Formally tell them you hold them responsible. State the cost, attach quotes, or your loss if written off, attached valuation salvage details.
Anything important to include in that letter?
Yes, use the words without prejudice. That stops it being used against you in court later. There's a sample notice in the booklet. There's also a sample reply if the other driver contacts you, including where to put your own insurance details if you're claiming through them.
Good tip. And remember, they might claim against you, right?
Absolutely. The other driver or their insurer can claim for their damage and reasonable costs, like towing or a hire car, but only for damage caused by this accident, not pre-existing damage.
Fault is often tricky. How is it decided? And what if it's shared?
Yeah, 100% fault is rare. Often both drivers contributed somehow. You need to be realistic about your own driving.
How do courts decide?
They look at everything: speed, position, lookout, signals. It's called apportioning liability. If you're found, say, 30% at fault, you can only recover 70% of your losses from the other party.
And that affects your insurance payout, too.
Yes. Plus, you'll likely pay your excess if claiming on your comprehensive policy. If uninsured, you have to pursue the other driver directly for their percentage of your damages. Getting legal advice on liability before negotiating is wise. Keep copies of everything.
What's the process for trying to settle the claim without court?
Communicate clearly. Provide your evidence, quotes, etc. Negotiate fairly. Keep records. If their insurer makes a verbal offer, ask for it in writing.
What if you can't agree with the other driver's insurer?
If you're uninsured, you can try AFCA, but there might be a dollar limit on what they can award. Did G $15,000 mentioned? If your own insurer is handling it and you're unhappy, you can also go to AFCA.
And if you do reach an agreement,
Get it in writing, signed by both parties. There's a sample agreement template in the booklet. Absolutely crucial to avoid future disputes.
if settlement fails, the next step is court a minor civil action. How does that start?
That first letter you sent, holding them responsible, acts as the required pre-action notice. Then you file a claim form with the magistrate's court.
What goes in the claim?
Details of the accident, why they're at fault, what you're claiming,
Mm-hmm.
repair costs, towing, loss of use, incidentals. Attach your supporting documents, quotes, photos, report.
Then you serve it on the other driver.
Yes, the claim must be formally served. The booklet explains how. The other driver, respondent, then has 28 days to respond.
What can they do?
Pay up, file a defense disputing it, or file a defense and a cross-claim against you for their damages.
What if they just ignore it?
After 28 days with no response, you can apply for judgment by default. If they do defend, you get a copy and notice of a directions hearing.
What happens at court? The directions hearing.
Yeah.
And if it goes to trial,
The directions hearing is an initial informal meeting to try and sort things out or set a path forward. Attend it. If
Yeah.
it goes to trial in the minor civil stream, it's less formal. Court orderly helps. Witnesses wait outside. Magistrate leads it like an inquiry, asks questions. Lawyers usually aren't allowed unless permitted. Speak clearly, sit down. The magistrate isn't bound by strict evidence rules. They act on equity, good conscience, and the substantial merits.
and if you win,
Yeah.
getting the money.
The court might order payment by a date or in installments, but you are responsible for enforcing that judgment if they don't pay voluntarily.
The booklet also has those templates, accident record card and sketch. Useful.
Very practical. The card ensures you get all the vital details at the scene. The sketch helps document how it happened, visually great for insurers, police, or court later. A picture tells 1,000 words.
And if people need legal help with a car accident claim,
The Legal Services Commission's legal helpline is the place to call for free initial advice and info.
great. A really comprehensive guide to accidents. Let's switch now to something that can really affect home life. Noisy neighbors. What are the common culprits?
Oh, the usual suspects. Barking dogs top the list often. Loud music or TV, shouting, banging doors, noisy cars late at night or early morning.
But some noise is just part of living near others, right?
Absolutely. The fact sheet acknowledges that. Not every little sound is a legal nuisance.
Are there actual legal standards for noise in SA decibel limits?
Yes, the Environment Protection Noise Policy 2007 sets guidelines. It has specific dBA limits for noise traveling to neighbors, differing for day and night, and for continuous versus maximum noise.
What about things like lawnmowers or power tools?
There are specific restricted times for those if the noise affects neighbors. Generally not between 8 p.m. and 8 a.m. or 9 a.m. on Sundays, public holidays. And there are thresholds. If the noise exceeds the background level by a certain amount, it's deemed too noisy.
And construction noise.
Also restricted. Usually not allowed to affect neighbors before 7 a.m. or after 7 p.m. Monday, Saturday, or anytime Sunday public holidays. Exceptions exist, like for essential traffic work, but they still have to minimize the noise.
What about noise from schools or pubs? Who handles that?
For schools, churches, childcare, contact the organization first. For licensed premises like pubs and clubs, complaints usually go to Consumer and Business Services, CBS.
If talking to your neighbor fails, what's the next step?
You can complain to your local council. They have officers who can investigate if the noise constitutes a local nuisance.
And if it does,
They can issue an abatement notice, ordering the person to stop or reduce the noise. They might also issue fines for ongoing breaches.
good to know there's an official route. Let's look at another boundary issue, retaining walls. What exactly is a retaining wall legally? Is it a fence?
Legally, it's a structure built to hold back earth where ground levels differ.
Hmm.
And no, it's not considered a fence. Different laws apply. Fences have their own booklet.
What laws govern retaining walls in SA?
It's a mix. Common law of nuisance, plus the Planning, Development, and Infrastructure Act and its regulations.
Do you always need council approval to build one?
Not always. Depends on the height it's retaining and the location. Generally, if it retains 1 meter or less, approval might not be needed.
Might not.
Yeah, because there are exceptions. Specific zones, council areas, tiered walls adding up to more than a meter, or if you put a fence on top and the total height exceeds 2.1 meters from the low side. Best bet. Always check with your local council first.
Who pays for a retaining wall on a boundary? That seems like a common fight.
It can be complex. It often depends on why the wall is needed.
Examples.
If you dig down, excavate, and that creates the need for a wall to support your neighbor's land, you generally pay for that wall.
Okay. What if you build up, add fill?
If you add fill and need a wall to hold your fill back, you generally pay for that wall. And you have to make sure you don't overload any existing walls.
What if there's an existing fill wall and the neighbor then excavates next to it?
The excavator generally pays for any new wall needed for their excavation and also pays to make sure the existing fill wall remains properly supported. But there's a regulation suggesting fill walls should allow for some reasonable excavation next door. So the excavator might argue the filler should contribute if the original wall wasn't built robustly enough. It can get messy.
What about walls next to council land, like footpaths?
They, including the footings, must be entirely on your land. No encroaching onto council property.
Can the council step in if a wall looks dangerous?
Yes, if a wall poses a safety threat, the council or planning authority can issue emergency orders requiring work to be done. But they usually only intervene in extreme cases. If responsibility is unclear, they might serve notices on both neighbors, but they don't usually determine who is legally liable between private parties.
Right, that clarifies retaining walls. Let's move to another shared ownership model. Strata titles. We have a legal guide on this. What's the basic idea?
Strata title allows individual ownership of units within a larger building or development, plus shared ownership and responsibility for the common property. It's governed by the Strata Titles Act, 1988.
And when a strata plan is registered, what's created legally?
A strata corporation. All the unit owners are automatically members. Its main jobs are managing the common property and enforcing the articles, the scheme's bylaws.
What counts as common property? It can be confusing.
Generally, it's everything in the strata plan that's not inside an individual unit. Unless the plan says otherwise, unit boundaries are usually the internal surfaces of walls, floors, ceilings.
So things like the roof, external walls, hallways, gardens.
Exactly. Those are typically common property. Internal walls within your unit are usually your responsibility. Things like balconies or yards attached to a unit might have height limits too.
What powers does the strata corporation have?
Lots. They can own property, make contracts, levy contributions from owners for funds, maintain common property, enforce the articles. They can even require work be done on a unit if there's a breach, potentially by previous owners too.
Can they enter a unit to do work?
Yes, with reasonable notice or by force in urgent situations, like risk of injury or major damage, sometimes needing a court order first to carry out necessary work. The owner usually bears the cost, though might recover it from the person responsible.
What about insurance? What must the corporation insure?
Mandatory insurance includes building insurance covering units and common property, public liability insurance, currently at least $10 million cover, and, if they have admin or sinking funds, fidelity guarantee insurance.
What's fidelity guarantee insurance?
It covers theft or fraud of the corporation's money, say by a committee member or manager. The cover amount is linked to bank balances, or a minimum of $50,000.
Can they insure other things?
Yes, they can take out other cover, like for office bearer liability. And owners have the right to inspect all the corporation's insurance policies.
Does the corporation insurance cover my furniture inside my unit?
No, usually not. That's contents insurance, which unit owners need to arrange themselves. Very important distinction.
Who handles the day-to-day admin? Is there a specific role?
Yes, the secretary. They handle meeting minutes, send out notices, deal with correspondence, convene committee meetings, general admin tasks.
Can owners get access to information, like financial records?
Yes, owners and prospective buyers' mortgagees can request info, contributions details, assets liabilities, planned spending. They can also inspect documents like accounting records, minute books, manager contracts, owner register.
Is there a cost?
Owners can usually inspect most things for free. Others might pay a regulated fee, especially for copies.
Like community titles, Strata has articles. What are they?
They're the bylaws governing the scheme. They're set when registered, but can be amended by a special resolution.
What do they regulate?
Unit use, common property use, trying to prevent interference between units. Things like noise, pets, parking.
Are there limits? Can they ban assistance animals?
No, they can't unreasonably restrict enjoyment, ban certain minor signs, or prohibit assistance therapeutic animals for residents or visitors with disabilities.
What if someone breaks the articles? Are there penalties?
Yes, the corporation can ask for compliance, try mediation, or if the articles allow it, impose a penalty of fine up to $500.
How does that work?
They issue a penalty notice detailing the breach. The recipient has 60 days to apply to the magistrate's court to revoke it. If challenged, the Corp has to prove the breach. Unpaid penalties can be recovered as a debt.
Who runs the show day to day? The management committee.
Yes, elected at the AGM. Terms usually run year to year. Members can be reelected. Vacancies can be filled by co-option by the remaining committee. They can appoint proxies. A strata manager can be appointed to help them.
Can committee members be personally liable if the corporation breaks the law?
Yes, potentially. For offenses against the Act, they could face penalties up to half the corporation's maximum penalty.
What happens at the annual general meeting, AGM?
Mandatory agenda items.
Great.
Confirm previous minutes, review accounts, set contributions, review insurance, consider expenditure statements, appoint auditor if needed. Any special business needs proper notice.
Do people have to declare conflicts of interest?
Yes. Anyone attending and voting must disclose any direct or indirect financial interest in a matter before voting on it. Failure to do so is an offense.
How does proxy voting work if you can't attend a meeting?
You can point someone else in writing, another owner, tenant, relative, even the strata manager, though that ends if their role ends.
Yeah.
But even with a proxy, the owner can still turn up and vote themselves.
What are the different voting thresholds? Resolutions.
Ordinary resolutions. Simple majority, 50% of those present voting. Special resolution. Needs 14 days notice with wording reasons. Usually needs 75% support of those present and voting, sometimes linked to total entitlements. Unanimous resolution. Needs everyone to agree. Used for big decisions like changing entitlements or the scheme description.
What if you need a unanimous vote but can't get it?
If you get enough votes for a special or even just ordinary resolution, those who voted for it can apply to the magistrates or Supreme Court to declare it sufficient. Notice goes to those who voted against it.
Strata managers seem common. What are their key obligations?
They assist the committee. They must disclose any commissions they get from service providers before the Corps assigns a contract. They must provide quarterly statements of fund dealings if asked, allow owners access to records within 10 business days, copies for a fee. Failure on these or trust account audits carries penalties.
Who pays the strata corporation's debts if it can't?
The individual unit owners are personally liable. They have a right to contribution amongst themselves, usually based on their unit entitlements.
What if work mainly benefits just one unit, like a blocked pipe serving only my apartment?
The owners benefiting might have to pay for work that solely or substantially benefits their unit and not the corp as a whole. Benefit means more than just ongoing maintenance. Cause might also be relevant, e.g., if you blocked your own pipe.
How are disputes resolved? Between owners or with the corp?
Lots of parties can apply to the corp, owners, occupiers, prospective buyers. Disputes can be about breaches, unfair prejudice, unreasonable decisions, unit use.
And the court's powers?
Broad. Order actions, demand info, order audits, rule on validity of articles decisions, alter articles, reverse decisions, terminate manager contracts for breaches, award damages, make interim orders. Non-compliance is an offense.
Can an external administrator be appointed if things go really wrong?
Yes, in extreme cases of governance breakdown. Application can be made to court by the corp, creditors, owners. Court is usually reluctant as there's clear incompetence or illegality. The administrator has wide powers, costs paid by the court.
What if a tenant in a strata unit is causing major problems? Illegal activity, nuisance.
Affected parties, corp or other owners, can apply to SACAT to terminate the tenancy. Legal advice recommended for that.
So the absolute key advice when buying a strata unit.
Get as much info as possible before you buy. Understand the finances, the rules, the issues. You're joining a corporation with shared responsibilities. Do your homework.
How are rates handled? Council, water?
Council and sewerage rates are usually billed separately to each unit. Water can be tricky if no separate meters. SA Water has options, but the corp is ultimately liable. Private meters are possible, but cost money.
And that point about common property maintenance costs.
Corp pays for general common property upkeep. But if work solely or substantially benefits just one or a few units, more than routine maintenance, those owners might have to pay. Cause can be relevant too.
The booklet mentions mediation services again, useful for strata disputes.
Yes, places like Uniting Communities Mediation Service can help resolve neighbor community disputes. It's voluntary, uses trained mediators, aims for agreed, non-binding outcomes. Can save costs, time, relationships. Either party can initiate contact.
Okay, that's an exhaustive look at strata titles. Let's tackle our final legal area, trees and the law. What's the first thing to ask if a neighbor's tree is causing issues?
Is the tree really the problem? And is the owner legally responsible? Start there.
When is a tree owner legally responsible for problems caused on a neighbor's property?
Generally under the law of nuisance. If overhanging branches or encroaching roots cause actual damage or substantial interference. But liability usually depends on whether the owner knew or should have known about the risk and
Or
failed to take reasonable steps.
what if a tree is right on the boundary line? Who owns it?
If the trunk is on the boundary, it's usually considered joint property of both landowners, unless the original planter is known. If unknown, assume joint ownership.
Can one owner just cut it down?
No, not without agreement. Cutting the trunk would damage the other owner's property. Significant pruning or removal needs mutual consent.
If a neighbor's tree is causing a nuisance dropping leaves, roots cracking paths, what can the affected neighbor do?
First, talk to the neighbor. Try to find a solution together. That's always best.
If that fails,
You generally have a right to abate the nuisance. This means cutting back branches and roots at the boundary line yourself.
any rules for doing that?
Yes, don't trespass onto their land. Don't make the tree dangerous or unstable. You usually pay your own costs for cutting on your side. And you should offer the cuttings back to the owner.
Other options.
Check with the local council. They sometimes have powers regarding dangerous trees. You can formally write to the owner requesting they fix the problem. If damage has happened or is imminent, you might recover pruning costs if you acted reasonably.
Can you get a court order to force them to prune or remove it?
Possible, but difficult. Usually only if substantial or irreparable damage is likely soon. Removal orders are even harder to get. Courts prefer to save trees if possible.
What should you absolutely not do?
Don't poison the tree or trespass to work on it. That's illegal, can lead to compensation claims, even criminal charges. Even for a dangerous tree, that's not yet a nuisance, you can't just go onto their land, warn them, and claim damages if it falls.
Do you need council approval to remove or prune trees on your own property?
Often, yes. If it's a regulated or significant tree under council rules or the state code, check with your local council.
Are there exemptions? When is approval not needed?
Yes. For removing certain listed exotic species, trees within 10 meters of a house, with exceptions, within 20 meters in high bushfire areas or dead trees. Also, maintenance pruning, less than 30% of crown, to remove diseased wood or risky branches is usually exempt. Pruning encroaching branches roots doesn't need approval unless it harms the tree.
What about urgent work on a dangerous regulated tree?
Allowed, if necessary, to protect people buildings. Minimize damage. Notify council ASAP. Owner applies for authorization later.
The booklet advises getting expert advice. From who?
Qualified arborists or horticulturalists. Nurseries can give general info. Think carefully before planting. Consider species, size, roots, location near buildings. And when building near trees, consider their impact too.
Why does the booklet mention specific legal cases?
To show the legal principles in action, they illustrate how courts have applied the law in real tree disputes and form the basis for the advice given.
And those legal and community resources listed.
Organizations like Community Justice Services, SASA, Mediation, Uniting Communities Law Center, Westside Lawyers, women's legal service places that might offer further advice, mediation, or legal help for tree neighbor issues. Contact details are provided.
Great overview of tree law. Our final topic, wills. We have a fact sheet. What's the main reason to have a will?
Simple. To legally state how you want your property, your estate distributed after you die.
What happens if you die without a will?
That's called dying intestate. Your property gets distributed according to a set legal formula to your relatives, next of kin. If no qualifying relatives exist, it could go to the government. The fact sheet gives examples: spouse no kids, unmarried parents alive, spouse kids.
Can you make your own will? Use a DIY kit?
Legally, yes, you can. Kits are available.
Mm-hmm.
But the fact sheet strongly cautions against it.
Wow.
A will is a vital legal document. If it's not drafted or signed perfectly according to law, it can cause huge problems, legal costs, delays, and might not reflect your wishes accurately. Professional preparation by a solicitor is highly recommended for peace of mind.
Who can you choose as your executor, the person who handles everything?
Any competent adult over 18. Could be family, friend, or a professional like a trustee company. You can appoint more than one to act together. Choose someone likely to outlive you.
Do they get paid?
Professionals charge fees from the estate.
Yeah.
Non-professionals can get professional help, lawyers, accountants, and those fees are also paid by the estate.
What actually happens when someone dies with a will?
The executor carries out the will's instructions, funeral arrangements, etc. They might need to apply to the Supreme Court for probate.
What's probate?
It's the court formally validating the will and confirming the executor's authority to collect assets, pay debts, and distribute the remaining estate to the beneficiaries named in the will, often needed for large sums of money or solely owned land.
How do you change a will if your circumstances change? New will every time.
For minor changes, you can use a codicil, but it has the same strict signing witnessing rules as a will, so professional help is still recommended.
What about big life events? Marriage, divorce?
Huge impact. Marriage-registered relationships automatically cancel any previous will unless made in contemplation. Divorcement of registered relationship cancels gifts powers to the former partner unless the will says otherwise.
So definitely need to update then.
Yes, get legal advice after separation, divorce, remarriage, new registered relationship. For any significant change, new partner, kids born, beneficiaries die, making a whole new will is usually the safest way to ensure clarity.
Where should you keep the original will?
Somewhere very safe and secure, fireproof if possible. Record the location and tell your executor or a trusted person. Solicitors, banks, trustee companies often store wills, usually for a small fee. It needs to be findable.
That provides a really valuable overview of the key aspects of making a will. Well, that officially brings us to the conclusion of our incredibly deep dive into a wide spectrum of South Australian law.
Yes, we have certainly covered a significant amount of legal territory today, ranging from the intricacies of shared property ownership under community and strata titles,
Right.
to the procedures for navigating court and tribunal fees, the legal recognition and implications of de facto relationships.
The serious legal consequences of drink and drug driving offenses, the importance of establishing enduring powers of attorney.
The complexities of family law, how to approach insurance claims after disasters, the general process of attending court.
Strategies for recovering debts, dealing with neighborhood disputes involving noise and retaining walls, and finally, the crucial considerations surrounding trees and the making of a valid will. Phew.
It's quite a list.
And it's so important to remind our listeners that this has been, a focused yet concise overview. We've tried to extract the key aspects and essential considerations from the provided Legal Services Commission resources within each of these diverse areas of law relevant here in SA.
Absolutely. The information we've discussed today, it really provides a foundational understanding of these legal topics, but it is crucial to remember that each of these areas is complex in its own right.
So this deep dive is really a starting point.
Exactly. A valuable starting point for your understanding and awareness, definitely.
So to you, our listener, please keep in mind that for your own specific circumstances, your individual legal issues, it is always absolutely essential to seek tailored, up-to-date legal advice.
Yes. From qualified legal professionals who can properly advise you based on the unique details of your situation.
Couldn't agree more.
And on that note, maybe a final thought for you to consider. With this foundational understanding of these various facets of the SA legal system that impact daily life, what particular area do you now find perhaps most immediately relevant to your own circumstances, or maybe most surprisingly impactful? And, what further questions does this whole exploration raise for you as you navigate the legal landscape around you?